Good evening to all of you. Welcome to Legal Matters by Sai Babu Sunkara. This evening we are going to discuss a case law on section 41A CRPC. You all know that according to section 41 CRPC, the police, even of the rank of a constable, is authorized to arrest a person without warrant if he is concerned, suspected in a cognizable offence. So they can arrest a person without warrant from a magistrate. This was in 1973. So later, during the year I think 2009 or so, an amendment has come, that is 41A CRPC. So 41 CRPC says, for the offences which are punishable below 7 years, the police can give notice under section 41A CRPC to the accused person, and if they are satisfied that the person will attend the court, they need not arrest him. This is a very good leverage or benefit given to the police. You know, the purpose of arrest is to secure the presence of the accused during the court on the dates of trial. That is the main purpose of arrest. That's why please remember, in CRPC it is said the police may arrest. Nowhere it is said that the police shall arrest. Right? So, with this introduction, let us go into the details of the case. Justice Kanyaganti Lalitha Kumari of Telangana High Court. Previously she worked in the AP, now she is transferred to Telangana. On 7th February 2022, while directing the police to take action under section 41A CRPC in the case of Syed Inayatulla versus State of Telangana in that bail petition number CRP number 8241 or 824 by 2022, held clearly that if the police wants to arrest a person under section 41A CRPC after giving him notice, the conditions should be followed and the permission from the magistrate should be taken. I repeat, the permission from the magistrate has to be taken. So the reliance is placed on the beautiful case Kumar versus State of Bihar 2014. So one should not forget this case, particularly as advocates. Kumar versus State of Bihar 2014. Now we will go into the details of the case. So, the accused person, Syed Inayatullah, was introduced to the complainant in that particular case, that is Central Crime, WCO, I think in Hyderabad city itself. Right, in the year September 2020, A1 was introduced to the complainant as a doctor. A1 introduced himself as a doctor who is working in Virinchi Hospitals, which is a famous link chain of hospitals in Hyderabad city. And he also stated that he is running a private clinic in Narayanguda. So the introduction was in September 2020. Ultimately, in January 2021, the accused, Syed Inayatullah, requested the complainant to provide 45 lakhs for running the clinic. He also assured that or promised that he would repay the amount by 31/3/2021. Such assurance is given. So based on that, he also assured that he would give lumps or a very good rate of interest also. I do not know how much of rate of is fixed. And lured by this or induced by this, please remember section 420, induced by this, the complainant procured money from his friends and relatives and paid 45 lakhs to the accused and his father twice, 2 times. On 16/1 he has given 25 lakhs. On 21, after 5 days, 21/1 he has given 20 lakhs, total 45 lakhs. Finish. So the date 31/3 has gone away, no repayment from the accused person. He moved so many times to him ultimately on one day. So they caught him ultimately. Sir, to be precise, I want to tell you that the accused gave a check for rupees 10 lakhs. So when it was produced before the account branch, it bounced. So this is the thing. So therefore, he filed a case under section 420 and 138 of the Negotiable Instruments Act before the Economic Offences Wing in Hyderabad city. The matter is under investigation. While so, the accused, that is Syed Inayatulla, he filed a petition under section for anticipatory bail, or we call it as pre-arrest bail, in the court for pre-arrest bail. So, having taken into consideration of the file, the measure of investigation, all these things, the Honorable Court directed the police to take action. The Honorable Court directed the accused person to surrender before the concerned police, and police can take action under section 41A CRPC following the Kumar judgment. So, court direction. Please remember, the court has directed him to go and surrender before the police, and the police are directed to follow the procedure under section 41A CRPC. Since 420, so of course it may extend to 10 years, but 7 years, we take it as an offence, very not so serious offence. Of course, the NY Act, it is a very, very simple offence. Only punishment will be maximum 2 years, or amount maybe twice. Suppose he has given a check for 10 lakhs, the compensation to be paid may be 20 lakhs. So, right. So anyway, the court directed police to take action under 41A. So since the court has given directions, they cannot do anything. So this was done in CRP 2020, 87 by CRP, Criminal Miscellaneous Revision, 87 2021 by 21. Right, okay. Then, as suggested, he took his lawyer and went to the police station and surrendered himself before him. So the police gave him notice under 41A CRPC. Then he was going to the police station, coming back, but no action. That is, they are not interrogating him, they are not asking him anything. So, while this was the situation, once again, they have come to the court stating that the police are not acknowledging the 41A CRPC. That means when he signed on it, normally it is itself is acknowledgement, but they have to do something. They must ask him to come to the police station for inquiry, for investigation. Whenever he goes, they are not saying the IO is not available. So many things are happening. So that is to say, the accused has filed a petition before the High Court stating that the police are not following the procedure under 41A, and also had suspicion that they may arrest him. Now, Honorable Justice clearly stated that when once they have given a notice under 41A CRPC, first of all, they are satisfied that are there any grounds to release him on bail, or whether he may try to escape. So, are there sufficient grounds to send him to court, to arrest him? In this connection, if the police wanted to arrest him, they have to take permission from the magistrate. So with this direction, the petition has been disposed of. So now the police have to be satisfied or to have to keep quiet after giving 41A notice, or if they want to arrest him, definitely they have to take permission from the court to arrest him. I think it may not be possible. Better police, they are wise people, they may definitely keep quiet. But anyway, to conclude, I want to tell you that this is a case law where the High Court has clearly stated that once a 41A CRPC notice is given, and if the police want to show the arrest, they have to take permission from the magistrate. That's all. That's the crucial point in this case. So please read the judgment and enrich your legal knowledge. Thank you very much.